but if you're not dialed in, you can't hear me say this, but there's a number on the screen that you need to call. So we're going to make sure everyone is on the call before we get started. And just so you know, you will be able to hear myself. I'm Shelley Rushi. I'm the Marketing and Communication Director at Allied Insurance Broker. And you will be able to hear Bob Zinselmeyer, our panelist. We will not be able to hear you, so don't worry about background noise, your phone ringing, anything like that. That won't disturb what we're doing here. So I'm going to give us just one more moment, and then we're going to start the presentation. Okay, it looks like everyone is in and logged in. So we're going to go ahead and get started. The first thing I want to do is go over a couple of housekeeping items for those of you who are not familiar with how a webinar works. If you move your mouse or touch your keyboard occasionally, it will keep your screensaver from coming on so that the presentation won't be interrupted. If you have any questions, on the menu bar there is a section listed as questions. If you click on the plus sign next to the questions, it will open up a dialog box. You can type questions in, and only myself will be able to see. And what we'll do is at the end of Bob's presentation, we will go over as many of those questions as possible. If we run out of time, Bob will contact you to answer you directly. We want to make sure everyone's questions are answered. If that webinar bar, the menu bar, is in your way, you can hide it by using the arrow in the left-hand corner, and I'll show you that in a moment if you're having trouble finding that. If you're having any technical difficulties, please call 1-800-263-6317, and that is the GoToWebinar helpline. Also, just for your information, if there's anyone from your office that couldn't attend today that you want to show this information to, we are recording it, and it will be available for viewing on our YouTube channel at youtube.com/AlliedInsurance. And really quickly, just so you can see what I'm talking about, this small arrow in this top corner right here is where you are going to be able to minimize the menu bar if it's in your way. Okay. Okay, a little bit about Bob Zinselmeyer. We're so happy to have him with us doing this presentation today. If you're not familiar with Bob, he is a senior litigation specialist with Specialty Claims Management. He's been working as a third-party administrator for the past 29 years, and he handles both product and general liability claims. You may have seen his name in SIA Magazine or Lifton Handlers. He is a regular contributor to both of those, and he can be reached at Zinselmeyer, that's ZINSELMEIER, at specialtyclaims.com, or you can call him at 314-569-9828, or you can go to their website at specialtyclaims.com. So thank you, Bob, for joining us. I'm going to go ahead and turn the presentation over, and he's going to get started. Bob, go ahead. Are we having an audio issue possibly? Okay, if everyone could hold on just one moment. sorry, folks. It'll just be one quick second while we get this audio issue worked out.
Give him control. Give him control.
Please excuse the slight delay. We were having some proverbial technical difficulties with the sound from the location where I was in. But once again, thank you everyone for joining us this afternoon. I appreciate taking time from your busy schedules, and I certainly trust that some of the information being provided today will be of value to you, that will aid you in your businesses, etc. I would also like to take this opportunity to thank Allied for asking me to work with them in this presentation. It was gratifying to get the request, and I especially want to thank this young lady, Shelley Rushy, who has been more than cooperative in helping me put this material together. So, having said that, let's start on with the actual seminar. I suspect that if one took the title, Anatomy of a Paper Trail, it would not rank high on a list of titles that would generate a lot of excitement or a response that says, gee, I just have to have the ability to listen to comments made about a paper trail. However, I think if you understand the significance of a paper trail, and that it may well, just may well, save your company literally thousands of dollars or hundreds of thousands of dollars, will make your company run more efficiently, and maybe even in some circumstances save your company, then I think that the idea of a paper trail becomes a little bit more cogent and a little bit more important in the life of someone who is working within the rental industry. I first became aware of this idea of a paper trail when I left the insurance industry and went into the business of being a third-party claim administrator. For 20-plus years, I was working within the insurance industry, and I can tell you flat out that in no time in those years did I ever hear the term paper trail. However, when I joined this third-party claim administrating company and was going to handle the claims for the Scaffold Industry Association Insurance Company, I heard the term paper trail for the first time. As a matter of fact, I joined that company in August of 1981, and I think it was some 60 days later that I was introduced to the term. Back then, there was a gentleman by the name of Victor Salibi, who was the executive director of the Scaffold Industry Association. Victor, knowing that I was going to handle the claims for the Scaffold Industry Association Insurance Company, began talking to me almost incessantly about this term paper trail. In looking back at those early days, I'm of the opinion that Victor had this angst about this issue because when he first joined the scaffold industry back in the early 70s, let's say that some of the scaffold dealers were not necessarily the most rigidly run or the most well-run dealerships. As a matter of fact, I would suggest that the idea of a contract was either a verbal one or perhaps a verbal with a handshake, and that paperwork probably consisted solely of a drawer for the accounts payable and a drawer for the accounts receivable. So I think because Victor was keen and he was very aware of the liability issues surrounding a scaffold dealer, became obsessed with this idea of making certain that the dealers in the rental industry, the scaffold industry, knew what a paper trail was and what a paper trail could and would do for them. When I first heard the term paper trail, I couldn't quite put it together. Did it mean that I was going to be forging some kind of a trail, or was it something that I was making that would only allow me to go backward? And when I think in those terms, I think that you should look at the paper trail in both fashion. One way, when you are preparing your contract with your customer, you're forging that trail, you're putting everything together. So the more complete that document can be, the better that trail will be in the end run. Where it comes into prominence, perhaps more importantly, is when that customer or a customer's employee has an axe to grind and wishes to bring some type of claim litigation against your company, wherein then you can rely upon what it was that you did at the beginning that will help you show what it was that you did, how you did it, and by whom it was done. And while all of that is very good, the paper trail really is not complete until you have that customer execute the contract on his company's behalf. Once you have the signature on the rental contract, that in effect is telling the world that the customer agrees with what has been put together within the terms of the rental contract. Whether it's the front side or the back side of that rental contract, that customer is agreeing with it because he executes it either on behalf of his company or if he is the owner of the company. And why is that so important? Well, when you think in terms of litigation, litigation really deals with many, many questions of fact. The way a trial is run, the judge basically makes all decisions with respect to the questions of law. However, a jury makes all the decisions with respect to questions of fact. So what this paper trail will do for you, it will either totally eliminate those questions of fact or reduce those questions of fact to where the question of fact is weighted in your favor by 90, 95 to 10 or 95 to 5 in your favor, that the jury is going to take your position based upon the quality of your paper. But I would suggest to you in most instances with a very complete rental contract and an executed contract, most of those questions of fact are going to be resolved, period. It's interesting when you think in terms of a trail, that the trail, as used in police work, the police will say that the burglar or the criminal left a trail of evidence. Well, that trail is leading the police to that entity, whereas when you look at it from our standpoint, the paper trail is simply supporting everything that you did in the manner in which it should have been done and in the manner in which it was agreed that you would do it on behalf of your company and on behalf of the customer. While the term paper trail may not be exciting, the fact of the matter is it is an extremely part of your procedure in the running of a rental company. So, Shelley, let's go on to the next slide. Contrary to the term paper trail never having been heard while I was within the insurance industry, the term loss control is certainly a part and parcel of the insurance industry. As a matter of fact, there are loss control specialists where they are hired to go out to inspect and view a risk, to make recommendations on what that risk could do to be a better risk, whether it's with respect to the first-party coverages, the fire coverage, et cetera, or if it's in respect to a manufacturer, what they could do better to make their manufacturing process more efficient, or to prevent, to make it a more safety conscious operation. I'm not quite sure that I agree with the term loss control. Loss control would suggest in some ways that perhaps you are going to be able to reduce your claims in total. I don't think that's ever going to happen. Anyone within the rental industry is certainly going to have claims at some point in time. For those who are in the scaffold and lift business, putting people up into the air, certainly is going to, at some point in time, produce a claim. So when you think in terms of the loss control, I would like to switch that term. I would like to take the loss control out of it and use it and say it is a way of doing business better, or simply stated, it's called best business practices. Because I firmly believe, after doing this for the many years that I've been doing the work, I have come to the conclusion that if one follows all of the steps within a well-built loss control program / better business practices program, not only will it help with respect to claims, but it will also help with respect to running a better business, a more efficient business, a business that will create and generate better profits. While certainly, as I suggested, claims are going to be forthcoming. What these ideas are going to do then, coupled with your paper trail, because these better business practices are certainly a part of the paper trail. So when a claim is being brought against you, is forthcoming, then the time to go back and see what it was that you did in these better practices that made it apparent and readily apparent that whatever you did was not a cause in the accident. The combination of your proper rental contract completely filled out, coupled with what you do with respect to these better business practices, certainly is the answer to successfully defending your claim. So I look at it from two standpoints. I look at it first from a business standpoint. I would argue long and loud that those of you who practice good business practices with respect to this quote-unquote loss control idea, you're going to run a better business and a more profitable business. I would say secondarily to that, that yes, indeed, when you do have a claim, you now have the tools in which to defeat the claims that are being brought against you. Which of these two are more important? I personally think that if I were in business, I would be wanting to do these better business practices for the sole purposes of making my company more efficient, making it more profitable, and yes, if indeed I get a claim, I've got the wherewithal in which to defend that claim. In the course of handling claims over the years, we've made a couple of studies as to the amount of time that it takes someone who is involved in one of these major catastrophic claims. Now, I'm not talking about the run-of-the-mill claim. I'm talking about a case that involves either multiple fatalities or a fatality, paralysis, things of that nature where the stakes are very, very high. Conservatively, and very conservatively, we have estimated the time that a dealer alone, not his employees, just the person who is in charge of the company spends in the handling of that claim amounts to 30 full working days, more than a month. So if you look at it from the standpoint that, gee whiz, 30 working days, a whole month is being devoted to a non-profit-making or non-money-making arrangement. So if indeed these better business practices are going to reduce the number of claims, make you more efficient, then you can understand why. Litigation not only is costly to the insurance industry, but it certainly is costly to you as the dealer for the amount of time that you have to devote to it in doing all the things that are necessary to properly support your defensive posture. Shelley, the next. There are many elements to a quality loss control program. The way we have it worked out at the moment is that we have strict ideas with respect to scaffold only. We have them for scaffold and lifts. And for full rental capacity, we have not completed our list of better business practices at this time. Frankly, they are in the mill, and I am hopeful that they will be in place within the next 60 to 90 days. But some of the things from a company that is in a full rental capacity, doing party rentals, tent rentals, stages, etc., things of that nature, there are some things that immediately come to mind, and there are many things that you can share with the people that we've already produced these better business practices for. But as an example, for those of you in the doing a full rental facility, just the idea of the contract. The contract is as important to you as it is to anyone within the rental industry. There are certain items of rental that do create the potential for claims. Tents, these party items, the items that are play items, I should say, the items where kids can slide down or can jump in, those things can be problematic with respect to creating injuries. Many times those play items are used for fundraisers. So when a rental agency rents them to the entity who's putting on the fundraiser, the handling of that is then given over to some other person within the organization to manage the plaything that is being used. Sometimes young teenagers are in that capacity when little kids are involved. Those areas are of concern and are items that we are working to include as to how to better protect yourself under those circumstances. The other item that creates claims from time to time are chairs. Someone rents 250 chairs for some type of a function. Are all those chairs adequately inspected before they go out? Are they inspected when they're installed, et cetera, et cetera? So in the next, like I say, hopefully 60 to 90 days, we will be working on putting those best business practices together. And in the same way it is for cranes, once we are finished with the full rental capacity entities, we are then going to start on the mobile cranes and what could be done to make their businesses aware of items that would help them in their day-to-day functions. With respect to scaffold dealers and scaffold and lift dealers, we have a total of some 19 items that would be applicable. And obviously for time consideration, I'm not going to be able to go through all of those. I do have them available, so if anyone would like a copy, let either myself know at where Shelley told you you can contact me, or alternatively contact Allied, and Allied will be more than happy to provide you with a copy of these items. But there are some salient ones that I think need to be discussed. For instance, the very first one is that all risk must have a written safety policy. Over the years, I have been more convinced than ever that if safety does not start at the top of the chain, safety is never going to be fulfilled at the bottom of the chain. So if someone who is in president of the company thinks that safety is not important, I'll bet you your bottom dollar that the guy who's out in the field doesn't think it's important either. So if and when that owner of the company, the president of the company, or whomever, decides to put out his idea of what he expects of his employees with respect to safety issues, then I'll guarantee you that that's going to filter down through the rest of his company. That is simply an absolute must, that safety in the rental industry is of top priority. We've already talked briefly about the rental contract, and I'm going to get into that in a little bit more detail in the next slide or so. But that's one of the issues that needs to be clearly enunciated in these Better Businesses practices, that the rental contract has to have a proper indemnification paragraph, pure, plain, and simple. And again, I will get into that in the next slide or so. In addition, we would like for a customer always to sign for the receiving of safety instructions, whether it's scaffolding or whether it's some kind of a item that comes out of a full rental facility. If there are safety issues or safety instructions that need to be accommodate that, they have to be given, obviously, and they obviously have to be signed for, that the customer acknowledges receipt of those. I would suggest to you that in the course of the things that I'm going to be talking about over these last 29 years, I believe that every issue that we have in these best business practices has been a litigated item in one fashion or the other. The issue with respect to the simple signing of the contract, who has authorized to sign the contract, these items with respect to what we are wanting everyone to follow. Every one that I'm going to talk about has been litigated in one fashion or the other, or part of a piece of litigation. As an example, whatever kind of risk you are and you have serialized equipment, it is absolutely necessary that service and repair records are kept by the machine in question. It is amazing to me that over the years we have stumbled upon co-defendants who did not have any records with respect to their maintenance. I'm astounded that someone who is renting a piece of equipment, whether it's a lift, a towable boom lift, or a scissors lift, or what have you, that is being allowed to go out in the field, and then if something happens, they cannot establish what it was that they have done over the period of years to maintain that piece of equipment. Those are but a handful of the 19 items that I wanted to talk about briefly. Again, because of the relative short period of time for this webinar, I'm simply not going to be able to do all 19. But again, please send for them, and I will be more than happy to get a set off to you. Shelley, the next slide, please. And I think from the tone of my presentation so far, I would suspect that you're gathering the idea that the rental contract is the true key to what it is that you do in your business with respect to better business practices and with respect to being able to defend yourself in the event of litigation. This aspect, the rental contract, is probably the item that we have litigated more than any other. The item of the question of someone not being authorized to sign the contract, not reading what was on the back side of the contract, things of that nature. And I can assure you that all of these things wherein the rental contract was properly executed, we have been successful in defeating whatever allegation was coming back against us. Perhaps the most important element to the rental contract on the reverse side is the terms of the indemnity provision. But before I get to that, there are a few things on the front side of the rental contract that I think everyone needs to have. And again, I have sample contracts that if you would like to see these, be more than happy to share them with you. In particular, because the back side of a rental contract may have as many as 25 separate paragraphs on an 8.5 by 11 piece of paper. That's a lot of paragraphs with a lot of small print. Therefore, it is imperative that you need to call out to the attention of your customer those paragraphs which we believe to be the most key and the most important paragraphs on the back side. In other words, if they don't read all 25 paragraphs, they need to review at least the 6 paragraphs that we're calling to their attention. And those paragraphs, very briefly, would confirm in that paragraph writing that the lessee has inspected the leased or equipment and will continue to inspect it. And then you need to identify the paragraph where that is. Warranties being disclaimed, what paragraph that is. That the lessee will report any and all accidents, what paragraph. Then, of course, the calling to their attention the defense and indemnity provision. That another item to call to their attention, that the lessee purchaser be responsible for compliance with safety regulations for all parties involved in using the equipment. Again, the paragraph. This is absolutely essential because it takes away any argument that the people have that, gee, you know, I didn't have time to read all 25 paragraphs. Well, you don't have to read all 25. These are the key paragraphs that you're going to do. To get around the issue of who has the authority to sign on behalf of the company, that can be resolved very simply. It needs to say something along the line that whoever is signing for the company has read the terms on the front and reverse side and agrees to abide by them. An acknowledgement of the receipt below by the lessee, the lessee's employee, his agent, teamster, or other authorized person shall conclusively constitute the lessee's agreement to this lease. That clearly takes away any allegation or argument that my truck driver, he didn't have the authority to sign that, so therefore the contract is not valid. This item has been litigated a number of times, and we have been successful. The indemnity paragraph to the rear side of the contract, in some ways for a webinar such as this, is a bit difficult to talk about. And the reason it is difficult to talk about it is because indemnity provisions vary from many states to many states. There are a number of states where indemnity provisions are almost identical in the way they are allowed to be formatted, but there are many, many states that have peculiarities to them. I would be doing a disservice in this webinar if I suggested to you a single item or a single idea for a proper indemnification paragraph. What I would suggest to you, however, is the following. When you go to prepare a well-written indemnity paragraph, you do not go to your local attorney, the guy who handles your real estate or whatever other transactions you go. You need to find someone in your city who routinely does defense litigation, someone who understands the vagaries of indemnification within that state, so that he can help you prepare an indemnity provision that will fit your state's demands. True, that might cost you a few dollars to get this done, but believe me, the time spent and the money spent to get yourself a well-written and authentically indemnity provision, authenticated indemnity provision, will be well worth the time and the money. In general terms, the statements with respect to indemnity provisions need to be pretty simple, pretty straightforward, and they need to say specifically what it is that you're intending for the other person to do for you. For instance, if you are asking the other person to indemnify you and your company for your own negligence, that has got to be stated in clear, plain language. It cannot be gobbled up in a string of other legalese within that paragraph. Again, I would request that if you're going to think in terms of having your indemnity provision looked at, do not go to your local attorney. Go to someone who is in the business of defending cases and is familiar with it, and you will get the best results. The next slide is, I'm going to talk about some imperatives that I think need to be talked about. And frankly, I have already talked about that, so we can skip ahead. We're doing okay on the time element. So I'm going to skip again to the back side of the indemnity provision. And again, as I suggested, a proper backside agreement is going to contain 25 paragraphs, and all of them are important. However, some of them are of lesser importance. In my own preparation for this webinar, I went through and highlighted those that I think are the most important. And there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 out of the 25 that are the most salient. 4 of them are listed on the slide that is currently on the screen. I've already talked about the indemnity paragraph. That is a whole issue that would take up another webinar all in and of itself. The other ones I think I've already talked about as well. The inspection of equipment, that was on the front side of the contract, telling them they better look at this. The warranty disclaimer, the reporting of accidents. That has reared its ugly head quite a few times over the course of these 29 years, that you have it in your contract that if someone using your equipment has an accident, they report it to you immediately. We've had, believe it or not, some very, very serious accidents that were never reported by the customer to the rental facility, notwithstanding the severity of injury, only to find out a year later when a summons and complaint comes in. While I would never suggest to anyone that they need to emphasize that accidents can happen as a result of using this equipment, the fact of the matter is they do. And I think that that is an issue that, because of your protection of yourself and your company, probably needs to be called to their attention. The same way with the compliance with safety regulations. Depending upon your familiarity with your customer, how frequently they have rented from you, how well you know their staff, regardless of those issues, notwithstanding all those things, you still need to provide safety information each and every time. If you don't, it's ultimately going to come back to haunt you. Sure enough, the time that you don't give them out, that something is going to happen, it's going to happen to somebody who's new on the job, who's not familiar with them, and you're kind of left holding the bag. Issues with respect to the front and the back side of the contract probably constitute 90%, well, maybe not that much, 75% of your better business practices / loss control issues. The other are going to be contained with how well you can support the issues in these 19 items that are outlined in our Better Business Practices material. Shelley, next scene, slide. There are a couple of things that I'd like to call to your attention. One of them is the idea of foregoing the continued problems with who has the authority to sign, et cetera, et cetera. And if you have a customer who is a very, very frequent customer, I would like to suggest bringing up the idea to him that you both enter into a master contract, a master agreement, that basically will encompass all of the issues that you need to be concerned about for the term of a year, let's say, and that all you would need to be concerned with then on the individual rentals is what it is actually that is being provided on the front side of the contract. You needn't get all of the issues worked out with your customer about what's on the back side, why it's important for him to read. This has already been done by the owner of the company who agrees. And again, if you're going to tackle that kind of a plan, then again I would strongly suggest that you do that by going to an attorney who's in the business of defending cases arising out of the rental industry, and see what you can do to get them to draft the contract. The idea would be that you and the owner of your customer, you and your customer, have come to a meeting of the minds of what is important to you, and he agrees with these issues and is willing to get into that contract. I've only seen a handful of these things done over the years. I'm going to tell you straight up front that they're not the easiest thing to sell, but the fact of the matter is that they are capable of being executed. It just takes some time and effort, but I'll tell you, it sure sidesteps a lot of hassles with respect to that aspect of a claim. The last thing I'd like to talk to you about is the contract with excuse me, my tongue is getting wrapped around my eye tooth and I can't see what I'm saying. I want to talk to scaffold dealers only at this point. There are times when a scaffold dealer who also erects may have a job where he is not in a position to do the erecting, but he does have the master contract with the contractor for the providing of the scaffold. And so therefore the scaffold dealer has to go to an outside entity in order to have the scaffolding erected. You now enter into kind of a different set of circumstances. The scaffold dealer who has the contract is going to provide the equipment, perhaps, and hopefully he will also provide the design of the scaffold. The erector then goes and erects the scaffold and complies with the design. If an accident happens, how did the accident occur? What were the circumstances of the accident? And depending upon those issues would then depend who is going to be responsible for defending the action. If the manufacturer, if the erector of the scaffolding doesn't do a good job, doesn't erect it properly, and the accident arises out of that circumstance, obviously then the erector and his insurance company would be responsible for the defense of that case. Conversely, if the allegation is that the scaffold was improperly designed but built properly, then obviously the original guy who designed the scaffold would be responsible. And in order to do this thing, what you would need to do is have an indemnity provision within the contract that would run to each entity. In other words, the scaffold dealer would say to the scaffold erector, if the accident arises out of my design, I will defend you. Conversely, if the accident arises out of the erection, improper erection, then the scaffold erector says back to the scaffold dealer, I will defend you as well as myself in the handling of this claim. I'm not certain how often such a circumstance arises. I had one particular client where that was the way in which they did business. They garnered the contracts, and then they had a subcontractor doing all of the erecting, and that's where this first came in the contract. Not so sure if it's done a lot throughout the country, but if you ever come into that circumstance, that is something that needs to be taken into consideration. Folks, we've covered an awful lot of territory in a relatively short period of time, and to be candid with you, I felt myself talking very, very rapidly at times, and due to the fact that we were a little bit late getting started due to some technical difficulties. I apologize for that, and I apologize if my speed of my verbal skills got to be too quick. But certainly go ahead and fire away any questions, and we'll go from there. Go ahead. The question being presented, how is delivery proven with a master agreement contract, assuming the master contract has already been signed? I think the answer to that is that the master contract would not include that provision, but the contract that's being done for the individual rental would incorporate that delivery, the delivery phase. Okay? Any other question? I don't think that there's any more questions, and once again, thank you very much for attending, and trust to hear from you if you have questions. Thank you.
Thank you, Bob, so much for the information. That was a lot. If anyone has any questions, please, please, please follow up with Bob or myself. Again, Bob's email is zinselemer@specialtyclaims.com, or you can call him at 314-569-9828. You can also reach me at Allied at S as in Sam, R-U-S-H-E, at allied-insbrokers.com, or at 1-800-569-9427, extension 207. And again, don't forget, we did record today's webinar, so if you want to watch it again, if there's anything you're concerned that you missed, or if you want to share it with anyone in your organization, it will be available on our YouTube channel at youtube.com/Allied Insurance. So thank you, everyone, for joining us today. Thank you, Bob, for the information, and we hope you join us for future webinars. Thank you, everyone.